Hello and welcome. Thank you for joining us today. We're going to examine some estate planning basics here at the University of Missouri. We appreciate you taking your time and joining us today. My name is Jen Jennings, and I'll be leading this session. But please know I'm joined by my colleagues, Ann Morgan and Arnaud Boutin. At the end of this presentation, we'll take questions, and all three of us will be available to field those questions for you. Should we not get to a question that you asked during this session, we'll try our best to contact you after this session is over. So with that, let's go ahead and get started. I'm going to make this a little better. There we go. Let's look at our agenda for today. We're going to explore what counts as an estate, what is probate, wills and trusts, and bequests, gifts to Mizzou. So to begin, what counts as an estate? Basically, real quick, it's all your stuff. Yeah. It's real estate, it's cars and equipment, life insurance, bank accounts, investment accounts, intellectual property, art, jewelry, clothing, all that good stuff, all your stuff. So one thing that's important to look at as you're starting to look at estate planning options and your property and what's going to happen to this stuff is how is the property owned? So one way is through deeds, titles, certificates. So these are pretty common. So real estate, your home, vehicles, motorized equipment, intellectual property. So for example, patents, copyrights, and such is an intellectual property that can be owned. Another type of property, another way that property can be owned is via account holders, such as life insurance, bank accounts, investment accounts. And then actual tangible property, such as possessions, art, jewelry, clothing, household goods, all things we own. I do want to point out some exceptions to that. And that, if you look on the right-hand column towards the bottom there, is rentals and provenance. Obviously, rentals, you're renting those. If you lease a car, you don't own it. If you're renting your home, it's not yours. But provenance gets a little trickier. Provenance is just the chain of ownership, and this usually applies to art and artifacts. And even though this may have passed down generations to generations, this precious object, you may not actually own it. So I think we're all aware of some very thrilling movies out there about stolen property and recovering of those stolen artworks and things like that. Just be aware that when getting ready to pass some of these property that you may think you own, there might need to be a check into the provenance of it, and you might be surprised. So just be careful on those precious objects. So what happens when a person dies owning stuff? Let's look at the left-hand column here first, the property personally owned. Most kinds of property are administered through the probate process via a will. So that's, by and large, most property transfers that way. You do see some kinds of property that will pass through a beneficiary designation. So, for example, you're noted as a beneficiary of a life insurance policy or a retirement plan. Those will pass through outside of the will. In the second column, this explores property owned by a revocable trust, and this is a little bit different than that's personally owned. This kind of property will be administered according to the terms of the trust and will not pass through probate. But then how it is similar to personally owned property is that some kinds of property, it will pass through a beneficiary designation as well through that process. Again, designations on an IRA or life insurance policy. Let's take a little look at wills and probate. The importance of the probate court is that it oversees the administration of the person's estate. So the court is aware and setting parameters, timeframes for certain tasks to be finished. The probate process is public, including any will filed. If there is no will, the court will determine who the heirs-in-law are and how the property is to be distributed. In-state succession is what that's referred to. So basically, you can decide where your stuff is going. You can make that decision, or the court will do it for you if you do not have a will. So either way, something's happening with your stuff. So you can be in control of that, or this court will take control of that. The court will appoint an estate manager, which is referred to as the executor, and the expenses related to administering the estate have statutory limits and will be approved by the court. So again, you see this oversight by the court. The process has deadlines and accountability. So your executor will be held responsible for closing the estate. And again, I do want to highlight that probate is a public process. Wills are public documents. So sometimes we hear about celebrities leaving certain assets to certain people and stories of such. That's because they're part of the public record, the wills are. So a little bit more about wills. A will, and this is a good point to keep in mind, a will is a document that goes into effect after you pass away. And then it distributes your assets there. So it's not in effect until you actually pass. If the person dies without a will, we've talked about that as in-state succession. And then to establish a will, there are a few documents that must meet the document must meet state requirements to be considered valid. First, you have to have a valid testator, which is the person who establishes the will. There needs to be 2 witnesses. This is an optional document, but self-proving certificate. This is something that you might want to talk over with your estate planning attorneys. This allows the estate to go through probate without actually bringing the 2 witnesses to the court to verify their existence. It's a document that can be done. And then another concept to bring up are holographic wills. These are not allowed in Missouri. Holographic just means handwritten. So just because you handwrite your own will and say, this is how I want it to happen, you do have to have two witnesses, and handwritten wills just are not accepted in the state of Missouri. So please check on that. Most states follow that line of logic. Let's look at who the people are that are involved when establishing a will. We're going to look at the testator and the executor. The testator is the person who actually signs the will. It's the person who is establishing the will for the dispersal of their stuff. This person must be over 18 and must be of sound mind. This is a low bar. There's not much controversy on this. It's pretty basic. You need to know, to be of sound mind, you need to know who you are, who you're related to, and know most of what you own. Not every single individual stock, you don't have to have that to rote memory, but you have to have a basic grasp on the majority of what you own. The other role to consider in your will or trust is the executor. The executor is named in the will. The administrator has fiduciary responsibility to the property to be administered on behalf of the estate. The executor must meet any deadlines, sell and distribute the property according sell and distribute the property. The executor must account for everything, such as paying debts, setting up any testamentary trusts that might be noted in the will. It's always advisable to, you might want to name an executor in your will, and you might want to have a successor executor, just in case, an alternative, just in case when you initially establish your will, your first choice might be a good choice at that time, but maybe as time passes, the alternative might be a better choice for you. So what can a will do? We're going to talk about what a will can do and what it can't do. What it can do is direct how your property should be disposed of or distributed. So you can direct the property to be sold and the money distributed, the proceeds, or you can direct the property directly to an individual. So for example, let's say you have your house. Maybe in your situation, you would prefer that the executor sell the house and then the proceeds be divided among your children. Or you might just decide to pass the house directly without sale to a specific individual. A will can handle either of those options. Your will can also name preferred guardians for minor children. It can be used, again, as we said in the last slide, to set up testamentary trusts or other arrangements such as life estate. Your will can also name which people or organizations receive property from the estate. So here's an example where you might incorporate charity into your estate plans. And then it's not uncommon, you do see sometimes funeral directions expressed in the will. And we just want to throw a bit of caution on that. Sometimes the will itself is not located prior to the funeral. The funeral, as we know, usually is pretty expediently takes place upon death. But it might take a while to find the actual will. So if there's something very specific that you're wanting, according to your funeral, you might want to share that with somebody in advance, so that it's not just exclusively in the will. What a will can't do. Let's take a peek at that. It cannot distribute property that is not held by the estate. So property that is held in trust, property that is passing through beneficiary designation, rights of survivorship, beneficiary deeds. So after your death, this particular piece of property would go on to person X. Has no legal effect until after the testator is dead. So that's another thing. Your will is not activated until you pass. And disinheriting spouses completely. There are what's called statutory share. Many states have this. It varies from state to state. But if you are married at the time of death, your spouse is entitled to some portion of the estate. Again, that would vary state by state. So you can't just completely disinherit a spouse. Let's look a little bit more closely at wills and trusts. So a trust is a document that creates a legal entity. Excuse me, pardon me. So trust, it creates a legal entity. Up until you pass, you are in control of the trust, and all the assets in the trust would be taxed to the person. But after death, the trust becomes a taxable entity, and that tax burden would fall to the trust. A revocable trust, we hear this a lot when we're discussing about trust. It's a kind of trust that can be terminated at will by the person who created it. So you establish this trust, you have it in place for several years, and you say, nope, I don't want it anymore. boom, you can terminate the trust. Again, the cast of characters that are affiliated with the trust. You have your grantor or your trustor. That's the person who creates the trust. The trustee is a person who administers the trust. And the beneficiary. And the beneficiary has rights to income and or assets in that trust. So what is a trust? Revocable trusts are very popular instruments. The grantor, the trustee, the beneficiary, they can all be the same person while the grantor is still alive. The grantor can be that all three can serve in all three of those capacities. The trust allows someone to step in as trustee if the grantor is incapacitated. So that can be a very useful tool if you set up a trust and later on in life are needing some assistance. This trust will allow for that. After the grantor dies, the trust becomes irrevocable. So up until the point that the trustor dies, the grantor dies, the trust is revocable. And then upon death, it becomes irrevocable, and then the trustee distributes the trust assets. It's important to note, too, that the trusts avoid probate, where we were discussing that earlier with the will, where that's a public process and has court oversight. Trusts do not. Some pros and cons of revocable trusts. Again, as we mentioned, we're looking at the pro side, the left side of the screen. It avoids probate. That also allows the trust to be more private. And the trust is not a public document, as is with the will. Another pro of a revocable trust is that it can easily set up more trusts or continue to operate as a trust after the grantor dies indefinitely. And the grantor is still treated tax-wise as the direct owner until death. Some cons or some things that might make you take pause on establishing a revocable trust. Just like the pro was that it avoids probate, the con is that it avoids probate. There is no direct court supervision. So this goes back to picking your trustee very carefully of your trust to make sure that they're somebody who's organized, that stays on top of things, that's going to get things done. Where the will, that's going to be mandated by court. The court will even have dates for certain things to be accomplished and certain tasks to be completed. All property in a revocable trust must be titled in the trust for the trust to have power over it. So it has to be specifically referenced. It can be expensive to set up. Can be a very prohibitive cost for some folks, where a will is probably less expensive to establish. And then a revocable trust must be formally amended if the grantor wants to make changes. So you set up in your estate that you have a certain you set up in your revocable trust of a certain provision is going to go to charity X. And a few years later, you decide, well, I'd rather have it go to charity Y. There'll be costs involved to make that change in this document. There are some other considerations outside your will and trust that are important to the estate planning process. And one of those is power of attorney. So power of attorney regarding finances. This allows someone to come in if you are no longer capable of managing your finances. It does not require a formal guardianship. That's a little more extensive process to establish a formal guardianship. This just allows someone that you trust, that you appoint, to come in and help you manage your finances. It works really well in concert with a will. And then the power of attorney is no longer in force once you pass away. Power attorneys for health care. This allows someone to make healthcare decisions on your behalf. And it's important to note here, particularly for any single adults that are listening, this is very, very important that you have somebody established as your power of attorney for healthcare. If you're married, decisions pass to your spouse to be made if there's any questions about healthcare. But as a single person, is it your parents, your siblings, which sibling? There's a lot of variation. And so this is a really crucial selection to make. Power of attorney for healthcare also allows that person to have access to your medical information, or if you want to have even more than just the power of attorney, if there's additional people you'd like to have access to that. And for our Missouri folks who are listening, if you go to the Missouri Bar Association website, they have fillable forms that you can download that are ready for you to complete and will be valid. So that might be a useful resource for you. Living wills, this is another important document to consider. It focuses on care decision. Living will is also referred to as an advance directive. And these are really specific for end-of-life care decisions to be made. So do you pull the plug or not? And when does that happen? You can outline all that very specifically. Also includes considerations for pain management, organ donation as well. So choosing an executor or a trustee. The best thing is choose wisely, choose wisely, choose wisely. Who is the most likely person to carry out your directions? Who's probably most responsible and organized, that's going to keep track of all these important processes, steps, and dates and times, and who makes good decisions. And when we say good decisions, who makes decisions like you would make them? So a conversation I had with a colleague not too long ago was your favorite relative doesn't always make your best executor. Your favorite kid may not be your best executor. So you want to make sure you have somebody who is going to be able to do all these tasks required. This one's a tough one, but it's important to address, at least touch base on, is minor children. Who would you like to take care of your kids in lieu of you? And that's a tough one. So some things to consider regarding that is choosing a guardian. And the guardian is going to be taking physical care. Who is the person who's going to take physical care the day in, day out of your child? Makes the best choices for your child's upbringing, such as schools, activities, day-to-day life. Another consideration that, in addition to a guardian, you may want to choose a conservator for your child, and that addresses financial care. So the guardian and conservator can be one and the same person, or they can be separate people. So maybe you have someone who is better positioned to take the daily care of your child, but you have somebody who is strengths are more in the accounting area and can take care of the finances and manage those for your minor child. So the conservator does have a fiduciary duty to your child's financial well-being. And the conservator will make choices regarding spending and saving of money on the child's behalf. So maybe the guardian says, hey, we want to go to this horse riding camp this summer and it costs an arm and a leg. The conservator might say, I don't think so. We need to be saving that for college expenses in the future. So the guardian and the conservator can work closely together. So just to start wrapping up, just considering including Mizzou in your estate plans, it can remove assets from your estate for estate tax purposes. Another reason you might consider giving is the beneficiary of a retirement account avoids income taxes and estate taxes. The gift is used as you direct. So Arnaud, and our team, we can work with you to help you attain your philanthropic goals. What would you like to see done with your charity? We can assist you with that here on campus. And also, making such gifts entitles you to enrollment in the MU Legacy Society. That's our honor society that recognizes donors who have made estate gifts and help support the mission of the institution. And it also can count towards your inclusion in Jeff Club, which is our premier honor society for our various donors. So please know that our plan giving team is here to assist you. And if you'd like to learn more about making an estate gift to Mizzou, different ways that estate gift could be made, and working, again, to fulfill your goals that you would like your charitable dollars to support, that'd be great. And I guess with that, what do we have next here? Are there any questions?
Hello there, Jen. Good afternoon. Actually, there were a couple questions that did pop up during the presentation. One of which actually kind of dovetails with what you were just now mentioning. Mm-hmm. Someone wrote, "I'd like to include Mizzou in my estate plans, but I don't know what assets I might need during my lifetime. Are there any options I might consider?"
Oh, that's a great question. Thanks, Arnaud. And thank you for the person who posed the question. Yeah, there's definitely options. So we can work with you to provide proper language to include in your will or trust or as beneficiary designation. And again, we can help you work to support what area of campus you'd like to support. But what's really, there's a couple options that offer you a lot of flexibility. We aren't fortune tellers, and we know exactly how much we're going to use in our retirement. And so that can be a little bit concerning that you don't want to give more than you possibly might need. So a gift through a will provision, a trust provision, those are nice. So we can work with you to get that all shored up where you want it to go if and when it does come to Mizzou. However, if you need that particular asset that you have allotted for charitable giving, if you need to use that, you have control of that during your lifetime. It's only until after your death, when your estate is being probated, that the gift could come to us. If it's there, if you need it during your lifetime, it's there for you to use. If you don't need it, you can direct that asset to charity or to other people. So that would be definitely an option that we would love to explore with you further. So thank you for that question.
And another question that popped up during the section about executor, someone wrote, "Can I have a friend as my executor, or does it have to be a family member, a relative?"
Good question. Good question. It can be your choice. It can be a friend or a family member of legal age to carry out your wishes. But again, it goes back to that choosing wisely. Make sure you pick a person who's going to be able to be organized and responsible. Make sure that they can take care of the estate as you've directed it and is in line with your thinking. So yes, either or on that would work. Were there any more questions?
No, that was it.
All right. Well, good. Thank you again for joining us today. I have our contact information there on this last slide. So we have our email address, phone number if you'd like to call. There's Anne, Arnaud, Cheryl, and myself. So thank you so much for joining us, and take care.